we will start with talking about, LLCs versus corporations versus partnerships. Which is best for your business? My clients come with these questions all the time, right? Limited liability companies, corporations, or partnerships are all subject to a certain level of asset protections, tax savings. We will be discussing the application of each and every one of these structures and how they can work for your business, for your investments, and which ones provide better protection and which ones are more suited or suitable than others are. I am Diego Alvarez Miranda, and I'm an attorney here at the firm Cunningham Legal. I'm the head of the business law department of the firm, and I was just named a Super Lawyers Rising Star as well for my practice as a business law attorney. So I will be gladly sharing all that with you. I am from Mexico, and I went to law school in Mexico. So now I find myself here at Cunningham Legal, and it's been quite an amazing journey. As you probably know, we have 17 amazing attorneys in the firm. We are giving this information for informational purposes only and not for legal advice, okay? We're not creating any attorney-client privilege. It is not legal advice, and we are not substituting this for obtaining legal advice from an attorney. Okay, any person who reviews this information should not rely on this information without first talking to counsel. Okay. So first we have to start with, talking about the business entity basics. Okay. Let's start with which types of entities we have here. At the end of the day, we have partnerships, we have corporations, and we have limited liability companies. I cannot, stress the amount of times that my clients have come in and asked me, you know what, I just bought a property and I hold it on my name, I rent it out, and I'm not interested in putting it in an LLC, a corporation, a partnership, whatever it is. It is important for each and every one of you to know that investment real estate is a business. It is treated for certain tax line item deductions that, you are better suited having those in a business entity or business organization. Okay, so a partnership is normally created when two or more individuals share the ownership of whatever business venture they're going into. They contribute resources and divide profits and losses. That is the initial, right? The initial threshold of you and I going into business, right? Whereas a corporation is considered a separate legal entity, which offers limited liability and issues ownership shares, okay? That's, your title to whatever, percentage interest you may have in that corporation are your shares. Unlike a partnership where shared ownership and LLCs, have a more different and more flexible structure, whereas the partnership has the partnership interests and are normally shared between each partner. Now, the LLCs came forth in the 70s as a combination between a partnership and a corporation. So the limited liability company is an entity that will provide flexible management, taxation, and provides that limited liability protection that a corporation does. However, the LLC is not subject to all of the corporate formalities that a corporation does. So it's the best of both worlds. It's the best of having a partnership, right, where things are done more, without that strict scrutiny that a corporation brings. But the LLC does afford that limited liability that a partnership, normally doesn't provide. Okay. Now, I'm going to get into the actual, what is a partnership question? Because a partnership normally is created as a general partnership, right? Whenever you go out with a friend, with a business partner, and start a business, even if you have not registered, if you don't have a partnership agreement, it's a partnership. Unless there are specific documents that don't, create a partnership, that there's an actual exclusion from partnership, right? A general partnership has unlimited liability, right? Meaning that it may subject all of your personal assets to seizure if the partnership becomes insolvent, right? Also, all partners must agree to any liability that the partnership incurs. And it should ideally be memorialized in a partnership agreement, right? But oral agreements are valid, right? It is very important to know that you may already be in a general partnership without you knowing if you're doing business with another person. I am not going to stress this enough. Liability is real, and the potential of having limited liability is very important to consider when making business decisions. Each partner in a general partnership will share equally the debts, the liabilities, and the assets of the partnership. Okay, they will contribute the same and they will take the same upon distributions or upon the winding up of that partnership. However, there is another type of partnership that many of you may be aware of. You may have probably heard about it before, which is a limited partnership, where you need at least two people, same as with a general partnership, where one will serve, or at least one of them will serve as a general partner, and the other ones will serve as limited partners. Limited partners are normally considered, equity partners because they bring in cash, right? While the general partner takes care of the management of the partnership. However, the general partner has unlimited liability, meaning that if the limited partnership goes belly up, the general partner will have to answer with their personal assets. Okay. While limited partners will have limited liability to whatever they put into this limited partnership. As it relates to taxation, both general partnerships and limited partnerships are what we consider pass-through entities. All right. A pass-through entity is that where the profits, the distributions, pass through directly to the members, to the partners. Okay. Unlike general partnerships, though, most US states govern the formation of limited partnerships, and limited partnerships need to be registered with the Secretary of State, at least in California. And this is the case for most states of the Union. Okay. Whereas a general partnership does not necessarily need to be registered. It's recommended, but not all of the time it's registered. Okay, which also can bring a little bit of uncertainty when you're doing business. Now, let's move on to discuss what a corporation is. Let's untangle that veil of uncertainty when we discuss about corporations. A corporation has shareholders, okay? Corporations have rigid corporate formalities. And these corporate formalities does not mean, hey, I have to meet with you once a year and we'll call it a day. It's part of it, but it is governed strictly by its bylaws that discusses provisions for shareholders, the appointment of directors who will respond to the shareholders, where the directors can also appoint officers such as your CEO, your COO, your CFO, right? The officers will always respond to the board. Any vacancies to the board or to the office of a director, and also to the vacancy of an officer, when are meetings taking place, where the corporate records should be kept, and how should they be kept, when and how to issue stock certificates, how are we going to indemnify the shareholders, etc. It is very important to know that corporations need to be incorporated with the Secretary of State, and they must have bylaws, okay? It is also recommended that some professionals use corporations, at least in California, pursuant to the professions code. Certain professions, such as doctors, attorneys, need to have a professional corporation. They cannot create an LLC, right? Whereas, for example, in Florida, you can have a professional limited liability company. Okay. Corporations are normally reserved for operating businesses that are engaging in a trade of business constantly. They're not holding assets for their growth. Okay. With that being said, there's two ways that you can classify a corporation, a C Corp or an S Corp. Most of you probably know that, you create a corporation and, it may automatically be an S Corp. That's completely wrong. All corporations, when formed, are C corporations unless elected to be treated as an S corporation. The S corporation is an election and is subject to pass-through taxation that we discussed in partnerships, right? This essentially means that an S Corp will pass through the taxation directly to its shareholder, where the C Corporation retains that profit and those activities within the corporation. Now, let's talk a little bit more about what a C Corp is. They can be great tools for complex businesses or businesses with foreign shareholders. You can qualify for a QSBS designation, right? This is normally reserved for startup companies that are expected to accrue gain and then be sold, right? And, for example, QSBS treatment can exempt up to $10 million in capital gains per year, excluded from the net investment income tax. This is something that is only reserved for C Corps when elected and when they may qualify for a QSBS election. That, going into the details of how to elect for QSBS can be discussed in another webinar specifically. But for all intents and purposes, if you already have a QSBS designation, or if you're looking into having a QSBS designation under your C Corp, you will know that California does not follow QSBS designations. So you have to be really careful on how you plan it. You have to plan it with a professional at your side, or else it can go very, very badly. Okay. There are definitely advantages to having a C Corp, right? Limited liability. If the corporation goes belly up, most shareholders just lose their investment. Officers may be liable for their actions, okay? Even if they're shareholders, they can still be liable and responsible for the losses of that corporation. However, shareholders can access capital, and the corporations can easily raise funds by, going public, and they can raise funds through all of these market trades. It's very important to understand that there is no limit to the shareholders that a C Corp can carry. Okay, getting out is very easy. You just, sell your stock certificate, you're on the other side. Then normally stock certificates of C Corps are issued to a holder, or whoever is holding it with a valid endorsement is considered the owner. However, there are disadvantages to having a C Corp. The setup does require time and expense. Bylaws must be carefully drafted. There should be a board of directors appointed. And if you have multiple shareholders, there is the need to have a shareholders agreement that precisely spells out what the rights of each shareholder will be, if there's going to be any restrictions, or if the way that the shares need to be sold. This is normally in privately held corporations rather than publicly held corporations, but you also have to comply with the corporate formalities that are assigned to a corporation by law of each state and also by the bylaws. For example, holding meetings at least once per year to designate and appoint a new board of directors or officers. I cannot stress enough that corporations have to follow bylaws carefully, and the corporate formalities need to be maintained. They need to hold regular meetings, keep board minutes, prepare annual reports and financials, right? They must keep all of the shareholders apprised of the business of the corporation, right? It's not, it's not unheard of that you suddenly hear in the news that pursuant to, the shareholders call held for NVIDIA, for example, is, it was spelled out that there's going to be a split of the stock, right? That is an example of how corporate formalities need to be held. The board needs to notify their shareholders of what their business is going to be. But more importantly, aside from the corporate formalities that you have to follow when owning and being part of a C Corp, it is subject to double taxation. Okay? C Corp taxation is fixed. Okay? It has flat rates both at the federal and at the state level. In the federal level is 21%. In California is 8.84%, which jointly we're looking at about 29.84%. There was the Biden administration tried to bring these federal flat rates up to 28%, which did not go through. It's staying at 21%. If the Tax Cuts and Jobs Act does not get extended past 2025, then these rates will go up to pre-2017 levels, and it's going to hike up to over 30%. So as you can see, the treatment for corporations under the current legislation is stuck at 21%, but it stays in the corporation. If shareholders want to take distributions, they have to pay their income tax subject to whatever personal tax rate they're subject to. Okay? The money is essentially taxed twice in a C Corp. So that brings us to questions. How do I avoid being treated as a C Corp? So to elect to become an S corporation, you have to actually request this to the IRS through Form 2553. You submit that stating, hey, I want my corporation to be treated as an S Corp rather than a C Corp. And in order to be treated as an S corporation, your corporation has to follow certain requirements. There cannot be more than 100 shareholders. All shareholders must be U.S. citizens or permanent residents, meaning they have to be U.S. persons. Okay? Corporations, partnerships, or business trusts, which are treated as business entities, right, cannot be shareholders. Okay? And there's only one class of stock. S corporations cannot issue Class A, Class B, profit, non-profit. They cannot issue essentially, voting stock and non-voting stock. It has to be only one class of stock, which is normal common stock. Okay? The IRS will even give you clemency if you file late. You just have to go through a separate revenue procedure, and you note that at the top of your 2553 form, and the IRS will normally send a letter of designation as an S corp a few months after you've treated to be elected as an S corporation. As we've discussed before, the S corp taxation is essentially a flow through into the shareholder directly. And the S Corp taxation takes into consideration the income, the credits, the deductions, and the losses that will be passed through to the ultimate shareholder. There are no corporate taxes as with the C corporation. All of the taxes of the income are passed through directly to the shareholder, who will then pay the tax. And California does tax either at a 1.5% flat rate or $800, whichever is higher. And this is considered gross receipts tax. Okay? There is a difference between dividends and salary, which do provide a tax opportunity, but it's important for all of you to know that S corporations require their shareholders that are acting with the business to receive a reasonable salary. Okay? You must pay yourself a salary, and that is completely separate and aside from any distributions of profit that you take. Okay? Been talking for too much, so I need a little bit of a cup of Joe to get me going. The distributions over reasonable salary will not be subject to your normal employment tax, right? They're not subject to the 15.3 Social Security and Medicare, the self-employment tax at 3.8%, for example. But you need to give yourself a reasonable salary, okay? So before electing to become an S corporation, please run an economic model with your financial advisor, with your CPA, to see if an S corp is, the right choice for you. And with that being said, now we're going to simply jump to the next potential use of business entity that we would want to use, which is a limited liability company. Okay, what is a limited liability company? What does it consist of? LLCs are a beautiful construct of business law. All of the owners are called members. Any entity or individual can be a member of an LLC. Banks cannot. Insurance companies cannot. They can only be C corps. Okay, and LLCs are governed by an operating agreement that will spell out what the members can do, how the manager will act. There are several ways that you can structure this operating agreement, as a member-managed operating agreement and a manager-managed operating agreement. Personally, in our firm, we prefer using manager-managed LLCs because you create a separation between ownership and management, even if the member is acting as a manager. It's a way to strip a little bit of the liability, okay? And also the operating agreement will spell out how capital contributions need to be contributed into the LLC, if there's going to be any additional capital contributions, right? When and if any meetings are going to be held, if any actions of the members or the management can be held without a meeting, it will be also spelled out in the operating agreement, how the records need to be kept, exit strategy for each member. It is very common to see transfer restrictions and rights of first offer or first refusal for the other members or the company in operating agreements. Also, indemnification provisions, which normally strip out all liability from the members, right? And essentially the company will indemnify its managers and members, right? And one important consideration as well is how that operating agreement needs to be and could be amended, sometimes by the manager, and it's in very limited circumstances by the manager, and mainly with the agreement of all the other members. Okay. The advantages of an LLC is simply asset protection, right? It protects the owner's assets from the LLC liability. You are always responsible for your own negligence, your own fraud. And, this is subject to something that we have not discussed, which is the corporate veil. Okay, I will get into the corporate veil a little bit in the future, but one important thing that you have to consider when running a business is the fact that you have limited liability. It doesn't mean that that limited liability will be respected. Okay, the difference between a member and the LLC is the corporate veil. But there are certain actions that can help a creditor pierce that corporate veil. For example, if you're commingling personal use assets with company's assets, if you're commingling, company's funds to use for your own benefit, going on a vacation, buying groceries, right? One important thing is not having adequate insurance can also put you in a jiff. But most importantly, when you're treating the LLC not as a separate business, but as a little bank account for you, that is it's the perfect storm to pierce the corporate veil. And that is called an alter ego effect. Okay. However, the LLCs do have less corporate formalities, are more flexible. You don't need to do a meeting every year to elect who the manager will be. Managers can be appointed for an indefinite period of time, okay? They can be subject to replacement or change upon incapacity, upon the agreement of the members, but there is not a specific provision that lets you know every year you have to make meetings, you have to, hold financials and give them to the members each year, unless the operating agreement spells, specifically states that you have to do that as a manager. And the LLC provides tax benefits that a corporation or a partnership does not, because you can elect to treat this entity as a corporation or a partnership, which is something that we will get into next. There are a lot of options, as you can see here. A single member LLC, or, says we live in California, community property state. Husband and wife are considered a unit, meaning that either a single member LLC or a husband and wife acting for their community can elect to be treated as a disregarded entity, meaning that you don't have to file a federal income tax return. Everything flows through to the members, and more importantly, it's the simplest structure without severing that limited liability, meaning that by putting certain assets in an LLC, treating it as a business, you're protected, so long as you don't create the alter ego effect that we were just discussing. Okay. However, California does carry a gross receipts tax. It's for most LLCs is $800 per year, and LLCs do have to file an income tax return every year in the state of California to Franchise Tax Board. LLCs can also be elected to be treated as a partnership, meaning if you have two or more people, including husband and wife as their community, they have a choice to be elected as a unit and a disregarded entity, or they can be elected. They can elect to be treated as partners, meaning that you file a Form 1065, the LLC issues K-1s to each of its members to determine their capital accounts, and it's the most common way that you will hold real estate, either through a disregarded entity or through a partnership structured LLC. And again, in California, you will pay your gross receipts tax of $800 every year, unless there is a gross receipts tax that, based on your revenues, it goes over that threshold imposed by the state of California. And on the other side, we see that we also have taxed as a corporation, S corporation, C corporation, meaning that an LLC can elect to be taxed as a corporation as well. Okay, it's very uncommon to see an LLC taxed as a C corp. It's normally when you have foreign partners and they specifically want that LLC to be treated as a C corporation, right? Most LLCs that are taxed as corporations will elect to be treated as an S corporation. You will have to file an 1120S and state income tax return every year. There's no federal corporate tax due or payable. As you remember, it will flow through to the shareholder, and I would never recommend treating an LLC as an S corporation or C corporation if it holds real property, okay? Because there is no adjustment of basis at death. Only the membership interest would adjust, the underlying property would not, and then you have an issue with capital gains, okay? Again, you can also elect to be treated to have that LLC be treated as a normal de facto corporation, C corp. Is it the most beneficial? Most likely not. Suitable in certain circumstances? Probably not recommended. It's very uncommon. Okay, you would file your 1120. If you see the difference between the tax returns that an S corporation files and the C corporation files, the corporate tax return form is called an 1120. When you have an S corporation, it's an S. And when you have a C corp, it's simply an 1120 with its state income tax return, subject to federal and state tax at the corporate level, and then upon distributions at the shareholder level. It is, again, not recommended for real estate investment. Okay. With that being said, most LLCs do not pay income and capital gains taxes on their profits directly because they're transferred directly to the member. Profits will pass through. They will each member will report them in their 1040, right? It's very specific. California LLCs, unless taxed as an S Corp or C Corp, are subject to the annual $800 franchise tax and gross receipt based on revenue, whichever is higher, right? If you have 250,000 in gross revenue, it goes up to 900 all the way to 11,790, right? When you have more than $5 million in gross revenue or more, okay? So you're probably asking at this point, why would I even consider doing a corporation, right? It is suitable in certain circumstances or when it is required by state law. If not, you can definitely go with an LLC. And this is what we will discuss next. Which one is better for you? Which one is more suitable for what your objectives are? Let's start by when not to use an LLC, right? Professionals, for example, in California, physicians, lawyers, accountants, real estate brokers cannot have LLCs for their professional practices, okay? This differs from state to state. As I mentioned, Florida does provide for professional limited liability companies, right? In California, professionals need to have a professional corporation, okay? It needs to be strictly stated on their bylaws who can be a shareholder. For example, attorneys. Attorneys cannot have shareholders that are not attorneys. Doctors cannot have shareholders that are not doctors, okay? This obviously, again, differs from state to state, but this is a perfect example of when you should not use an LLC. Now, if your gross receipts are high, your margins are small, a corporation might be a lot better. Consider a corporation when, you have lots of revenue, but not a lot of profit. California gross receipts tax goes up to $11,790 on more than $5 million, as we discussed. And this is regardless of profits. So again, run an economic model before choosing a business structure, either an LLC or a corporation, and the way, if you do choose an LLC, how it will be taxed. When can you use an LLC? When you're providing independent contractor services and you're not subject to the limitations of the Professions Code, and you're not required to have a professional corporation. When you're running a small business, when managing personal investments such as real estate, right? You can decide to be taxed as a disregarded entity. This is what most of my clients do. Most of my clients, we prepare LLCs for their real estate, and we keep them as disregarded entities unless we need, for some reason, to have them taxed as a partnership, right? Real estate investment, again, is very important to not hold it in your personal name. The best way that you can achieve limited liability protection without suffering of negative tax consequences is through the use of an LLC, taxed as a disregarded entity or taxed as a partnership. Okay? So we discuss what is the dilemma of using either an LLC or a corporation. We've been stating corporations, when you don't really need them and where they're not structured with professional advice, there are very bad tax consequences. I'm going to tell you a little story that I'm seeing with a lot of my older clients. Back in the day when LLCs were not a thing, they were not created, and people did not want to hold real estate in their personal names, professionals stated, hey, let's just put in a corporation tax as an S corp. Everything is peachy until they pass away. Once they pass away, we have to deal with their beneficiaries and how to offset the huge capital gain liability that they have because the property wasn't an S corp. I normally see these structures when property was acquired in the 60s, right? Early 70s, LLC started to be a thing in 79. So it's not out of this world to see, people still holding real property in S corporations. When unfortunately that person passes away, we have to, consult with CPAs. We have to get, an original basis of when the property was acquired and put in the S corp. Then we have to get appraisals for date of death. We have to essentially take out the property. But the problem is, well, I'm a shareholder. I'm not selling it. What is the issue? Why can't I just take my property? Because in an S corporation, in a corporation or in an LLC taxed as a corporation, any transfer of the corporation's assets to the shareholders or to the members is considered a deemed sale transaction. So it doesn't matter, okay, if you're not selling it. The IRS considers that transfer back to you as a sale. And capital gains tax are triggered, okay? Whereas with a partnership or an LLC taxed as a partnership or disregarded entity, upon death, we just file a form with the IRS. We get an adjustment of basis in the membership interest. Together with the property, we can transfer it freely to the members of the LLC without any, negative capital gains tax implications, right? There is a way that to offset that capital gain in an S corp, but that opportunity normally presents once, either one spouse passes away and it was held as a community property asset, or when the last spouse passes away and the beneficiaries receive that. So again, it's very limited what we can do with S corporations that hold real property. The LLC formation, it is complex. There's a lot of things, nooks and crannies that we have to go through for each client and their particular purpose. Each case is different. If it was easy, there's probably something that we need to review, okay? You have no idea how many clients come over here and ask us, hey, I did this in the legal suit. Fine. We review the operating agreement and they make, mistakes because they were not advised properly, or they were not advised at all. And we see LLCs being managed by the managers when it's a member managed entity. So then we have to amend articles of organization. We have to redo the operating agreement. And then the clients, whenever we bring back a huge red line of their operating agreement, they just look at us and say, okay, we're at your mercy. Now, corporations, again, subject to double taxation if not elected to be treated as an S corp. Whereas an LLC can be elected to be taxed as a disregarded entity, as a partnership, or as a corporation. A corporation, as well, you can use an S corp status, but you can also use that in an LLC, okay, and be taxed as a pass-through entity. You're probably wondering why I haven't recommended using a general partnership or a limited partnership. Limited partnerships, I only use them in very specific circumstances, either for estate planning purposes or when we're doing projects of syndication, right? General partnerships are not recommended. At least I don't recommend them, because we can achieve the same objective with an LLC taxed as a partnership, with the added bonus of having that limited liability. Again, I prepare asset protection structures for my clients every day. And the peace of mind of knowing that when those structures are treated as separate businesses, there is essentially a corporate veil that protects that client from liability. And that is liability from claims brought within the LLC. And there are ways to also protect your assets held in LLCs from something we call outside liability, when you get sued personally. We essentially create complex LLC structures using holding companies and other interesting avenues to make sure that you're protected inside the LLC and outside of the LLC. And we can definitely help you with that. With that being said, let's talk a little bit about LLCs for independent contractor services. You have the tax flexibility. You can form an LLC. You don't have to have annual minutes, and you can still elect to have it as an S corp and get all the benefits that an S corporation offers for a person that is providing services. Okay, it also provides a great opportunity to plan for your retirement. Okay, you can have a lot of different fringe benefits together with the S corp, right? You can save on taxes. You can claim deductions. But the LLC will grant you with management flexibility. You can elect to be treated as a manager-managed LLC, separate the ownership from the management. It could be you. It could be a trusted individual, right? It could be your kids. But again, this does not work for everyone. California professionals subject to certain professions cannot have LLCs. They should have professional corporations to deal with their business. As always, we recommend speaking with a licensed attorney. And as you can see, we're going to have a related webinar to discuss income tax reduction strategies and how to deal with 1099 income. So please be sure to tune into that one. It's going to be a very interesting one. And now let's shift a little bit. What about small businesses? Okay. Again, I will never get tired of stressing out that you have the tax flexibility in LLCs. Disregarded entities, partnerships will pay the gross receipts tax ranging from $800 to $11,790. The S corporation will be subject to that 1%, 1.5%, or $800 state franchise tax, whichever is higher. Again, run an economic model. Aid yourself from the benefit of having professionals at your side, helping you make these decisions. The advantages for small businesses is, first and foremost, flexibility. You have that liability protection. You have flexibility of avoiding that corporate formality. You have no idea how many clients come to me with a corporation and say, whenever I ask them, hey, where's your minute book? When was the last time that you did your annual meetings? Oh, I don't know. It's a corporation that's been, 20 years running, and they stopped doing their annual minutes 15 years ago. And then we have to go back in the corporate record, set everything straight, because if you don't comply with corporate formalities, guess what? You're open to liability, that piercing of the corporate veil that we all, are so afraid of. Okay. And one important thing, if you're a small business, husband and wife, mom and pop shop, right, you could be considered a disregarded entity. So it will not affect the way that you've been doing your taxes for years, but you will have that benefit of disregarded of the limited liability offered to disregarded entities, right? So these vary state by state, but you typically file state tax returns in California. Some states may vary. Okay. Now, very important, LLCs for personal investments. Holding assets within LLCs segregate those assets from personal assets, right? Holding corporate companies are great tools for estate planning purposes and for asset protection purposes. We do them every day, okay? There's the usual benefits of the LLC, fewer corporate formalities, flexibility in management, flexibility in distributions. You're not taking away anything from your current structure. You're only bolstering it. Remember, protection comes with segregation. So you may have a holding company, and you may have many businesses or many real estate investments, which we're going to talk about that now. If you have multiple residential, investment properties, you could group up to 4 units into one LLC. Again, I'm always a huge proponent of separating all of those units if possible, right? This provides asset protection. It's essential for commercial properties though, okay? Each commercial property should have its own LLC, or multifamilies that are 5 or more units should be in an LLC. This is essential. This is not a recommendation. This is something that if you don't have it, you need to do it sooner rather than later, okay? Ranching and farming, very important. You can get tax benefits, and you can also claim for certain property tax exemptions when you are running farmland as a business, okay? You have the asset protection advantages. You isolate personal liabilities from business liabilities and accountings, okay? There's flexibility in management and distributions. We have been talking about this, and it's very important for you to know that you're just protecting yourself. You have no idea how many clients come through the door and say, oh, an LLC is very complex. Once we go through what could happen in the event of a lawsuit, tenant coming after you, or, going down the highway, crashing against a bus full of attorneys, and then, attorneys will sue you, right? If you have a proper structure, you can say, okay, sue me, great. Let's see what happens, right? Essentially, LLCs beat corporations. I think that I've made it very clear. It can be very easy to get into a very difficult, it may be very easy to get into a corporation, but very difficult to get out of it. Whereas having an LLC taxed as a corporation, it doesn't mean that you can just revert it back to a partnership. You have to jump some hoops in order to do that. LLC taxed as partnerships or disregarded entities are far better for real estate investments. I would say it's the only option for real estate investments. Never, or please try never to hold, please, real estate within corporations, okay? Owning real property in a corporation is not a good idea. And when moving property in and out is what we've discussed. It's considered a deemed sale transaction. You will be subject to negative capital gains tax implications. And we have to jump a lot of hoops in order to get that basis off that capital gains tax offset, because you do not get a tax basis on the underlying assets of a corporation. As with anything, as Jim would say, this requires care and feeding. Use your 3-legged stool. Have an attorney. Have a financial advisor. Have a CPA. Okay? Professionals need to be involved. This is not a do-it-yourself thing. You can try, and I will see you here to fix it. It's all good, but at least try to do it with your professionals, because they do require care and feeding. Once we set up those structures, it's something that needs to be continuously fed, cared for, in order to avoid that piercing of the corporate veil. Okay? Other options, which I'm not going to get into that much, are sole proprietorships and general partnerships. Again, I will not recommend general partnerships. You may already be in one and you don't even know it. Okay? Sole proprietorships, you have essentially, you're conducting businesses without a formal business entity, which exposes you and your assets. Okay? There's no liability protection. It affords little credibility. And state default laws apply, which, they're standard, but they're not, meant to protect you. They're the ground floor, and you can start building from those. For partnerships, getting out of partnerships is tricky. There's partnership taxation. Partners have fiduciary duties to one another, and there's joint and personal liability. You're jointly and severally liable, meaning that they can go after your personal assets. And by they, I mean creditors, predators, and other traps that are out there. Now, this is the bonus estate planning tip. Make sure your living trust has S corporation provisions, qualified as a QSST or an ESBT. Okay? You need to make sure that your S Corp has S Corp language. Okay, electing small business trust or qualified subchapter S trusts, because if your trust does not have these language spelled out, the S Corp, the famous S Corp language, then that S Corp could default back into a C Corp, and you're subject to double taxation. Discovering this too late will result in back taxes. And with that, I'm just going to say that you can visit us at any other office locations in Northern California. I'm personally in Auburn, sometimes in Sacramento, at least once a week. We have Oakland and Montclair Village, San Francisco, San Rafael, and Walnut Creek. And also in Southern California, we have our Pasadena and our Westlake Village office. With that being said, I still remind you to subscribe to our YouTube channel, and please, if you can, join us to our February 27th webinar to discuss a little bit more about business planning with Jim. You can register at the link below, and I am happy to, be there as well. Now, we are also having another fire recovery seminar, and we're going to talk about, rebuilding with resilience and tax awareness for those affected by the fires down in Los Angeles. So if you're affected by that tragedy, please come to us. We're ready and willing to help you. Okay.